This is Immigration Attorney Robert Bell. The new administration has been carrying out new and unprecedented enforcement operations against members of the immigrant community residing unlawfully in the United States. Members of the immigrant community residing unlawfully are protected under the United States Constitution and have certain rights that they should be ready to assert if contacted by an immigration law enforcement officer. The first of these rights is the right to remain silent. You are not required to answer questions from an immigration law enforcement officer. You are not required to show identity documents. You are not required to answer questions about where you were born or what your immigration status is in the United States. If you are approached by an immigration law enforcement officer and choose to remain silent, you should tell the officer, "I choose to remain silent." You have the right to an attorney. You may tell the officer that you do not wish to speak or to sign any documents until you speak with your attorney. If you are currently represented by an attorney, you should carry with you the attorney's contact information and a copy of Form G-28, indicating that there is a lawyer who has your permission to speak on your behalf to the government. If you do not have an attorney, you can request an attorney. You can also request that an immigration officer provide you with a list of free legal services so that you may request a lawyer's advice before proceeding with speaking with an officer from the government. If an immigration law enforcement officer appears at your home and knocks on your door, you are not required to open the door. You should first determine the identity of the person knocking on your door. If they claim that they are there to enforce the immigration laws against you, you should ask them if they have a search warrant. A search warrant is a document signed by a judge allowing a law enforcement officer to come into your home. A search warrant should include your name, your complete address, and should have the signature of a judge. An order of removal or an administrative warrant for removal is not a search warrant, and you are not required to open your door and surrender to an officer for the Immigration Service. Due to these new administrative policies, we are providing the following recommendations to immigrants residing unlawfully in the United States. Carry with you a list of your constitutionally protected rights. Our firm is providing a list of your constitutionally protected rights on a card that is available upon request from our office. Carry contact information for the attorney currently representing you so that that can be provided to any officer who asks you questions. If you have any processes currently pending with the Immigration Service, carry receipt notices of those processes as well as a Form G-28 for the attorney currently representing you. You should also carry with you 2 years of evidence of your presence in the United States. We strongly recommend that any immigrant residing unlawfully in the United States does not drive unlawfully without a driver license. We also do not recommend domestic air travel. Finally, if you have a final order of removal and are required to appear to an ICE sub-office under an order of supervision, we strongly recommend that you speak with your attorney beforehand for advice as to how to be prepared for your meeting with an ICE officer.